West Idahosa, we have known you for quite a long time, right from your days in the House of Representatives and now as a senior lawyer. At this stage of the process, perhaps what one should be looking at is not just where INEC dropped the ball. I want you to identify those places where they dropped the ball. But then or equally importantly, is what can be done differently to re-engender trust in the process and ensure that it is concluded in such a way that this hasn't been an exercise in futility.
Well, thank you very much. The last time I was here, I did say that INEC showed commitment, got a few decisions right. He didn't postpone the election, promised the nation that he had enough resources to proceed and was determined to continue with the process in a credible manner. But as events have unveiled, it does appear to me that the commission dropped two major balls. The first ball they dropped was that they probably did not estimate the legal implication of the mode of transmission of election results. It's so key. It has been held by the Supreme Court that the process of voting does not just start with casting the ballot paper. It starts with events before then, up to the announcement of the result. He said there must be substantial compliance with the law. I would like to particularly draw your attention to the fact that one of the reasons today why collation is having some credibility problems is that the basis for collation as provided by the law is that when there is a dispute, section 64 of the Electoral Act has provided the background for resolution of such disputes. And it mentioned two key steps that must be taken. One is that the collation officers must revert back to the electronic data transmitted on election date to compare with the manual results in resolving the contested figures. The second is that the data which was collected electronically from each polling booth must now be put to resolve the dispute. So you can see the type of resolution going on now. They are not able to electronically resolve these disputes in these collation centers. The International Conference Center is also a collation center. The collation center for collecting the results of the presidential election. Those who say that resolution of disputes cannot take place at that level, they got it wrong. The INEC commissioner is the chief electoral officer, and in fact is the returning officer for this particular election. He hasn't got the electronic details to reconcile the figures that are disputed as provided by the law. The same thing goes to the INEC guidelines, which were made by INEC itself, pursuant to section 148 of the Electoral Act. It talks about the mode of resolving disputed figures. The question now is, all INEC is trying to do is persuade people, take it easy, let's finish the process, go to the tribunal. It's unfair. It's unfair to stifle the process, to undermine the law, simply because there's a tribunal to be attended. That's not correct. What about all the monies voted? What about the reassurance given to both this country and to the international community? What about the damage to the psyche of the average voter, particularly the new voter? What about those who have never voted in their lifetime but have been of voting age over 20 years ago, who saw this as a chance to embrace it? So I think that was a major flaw in the election. The other point is that INEC does not seem to understand that you can't just recruit anybody you like to conduct this election. Under the law, you want to subscribe them to a loyalty and neutrality oath. Section 28 of the Electoral Act is very clear. What happens to this oath? Do they realize that when they take this oath, they become obliged, both to the commission, to the nation, and to the public, From what we have seen and from the pictures and clips seen on television, it appears there has been brazen abuse of the oath of office, if indeed they took any. And if they didn't take any, again, that is substantial non-compliance with the electoral process. So it is painful that an election that would otherwise have been a watershed in the history of Nigeria's electoral ecosystem has been mismanaged, in my view, not by the politicians, but with the greatest respect, by the umpire. These will be my opening remarks as far as these issues are concerned.